Hello, everyone. Welcome to Internet Law Review. Today, we're here with another decision from the United States Supreme Court, the case of District of Columbia versus Wesby, the story of an epic house party. Have you ever been to an epic house party? Well, have you ever been to an epic house party so epic the United States Supreme Court themselves got involved? If so, your name is Wesby. This is a story of this house party. This is a 9-0 decision written by the United States Supreme Court, Justice Thomas writing. We're going to cover the law, but first we're going to cover a little bit about what happened at this house party. So you might say to yourself, well, how epic was this house party? Let's let Justice Thomas himself tell you a little bit about it. Around 1 a.m. on March 16, 2008, the district's Metropolitan Police Department received a complaint about loud music and illegal activities at a house in Northeast D.C. The caller, a former neighborhood commissioner, told the police that the house had been vacant for several months. When officers arrived at the scene, several neighbors confirmed that the house should have been empty. The officers approached the house and, consistent with the complaint, heard loud music playing inside. After the officers knocked on the front door, they saw a man look out the window and then run upstairs. One of the partygoers opened the door, and the officers entered. They immediately observed that the inside of the house was in disarray and looked like a vacant property. The officers smelled marijuana and saw beer bottles and cups of liquor on the floor. In fact, the floor was so dirty that one of the partygoers refused to sit on it while being questioned. Although the house had working electricity and plumbing, it had no furniture downstairs other than a few padded metal chairs. The only other sign of habitation were blinds on the windows, food in the refrigerator, and toiletries in the bathroom. In the living room, the officers found a makeshift strip club. Several women were wearing only bras and thongs, with cash tucked into their garter belts. The women were giving lap dances while other partygoers watched. Most of the onlookers were holding cash and cups of alcohol. After seeing the uniformed officers, many partygoers scattered into other parts of the house. The officers found more debauchery upstairs. A naked woman and several men were in the bedroom. A bare mattress, the only one in the house, was on the floor, along with some lit candles and multiple open condom wrappers. A used condom was on the windowsill. The officers found one partygoer hiding in an upstairs closet and another who had shut himself in a bathroom and refused to come out. The officers found a total of 21 people in the house. After interviewing all 21, the officers did not get a clear or consistent story. Many partygoers said that they were there for a bachelor party, but no one could identify the bachelor. Each partygoer claimed that someone had invited them, but no one could say who. Two of the women working at the party said that a woman named Peaches, or Tasty, was renting the house and had given them permission to be there. One of the women explained that the previous owner had recently passed away, and Peaches had just started renting the house from a grandson who inherited it. But the house had no boxes or moving supplies. She did not know Peaches' real name, and Peaches was not there. Having described the factual background of this epic party, let's talk a little bit about the legal background and why the United States Supreme Court is hearing this case. The respondents, 16 of the 21 partygoers, sued the District of Columbia and 5 of the officers. They sued them for false arrest. The parties claimed that the predications of the allegation they arrested was without probable cause. Under the Fourth Amendment to the United States Constitution, any search and seizure, and a seizure includes seizure of one's person, which is an arrest, has to be made reasonably, and it has to be predicated upon probable cause. So the people were arguing that there was no probable cause for their particular arrest. The district court found there was no probable cause. The district court found that under the district's law, probable cause to arrest for unlawful entry requires evidence that the alleged intruder knew or should have known that the entry was against the will of the owner, and in the view of the court, the officers had no such evidence at the time they made the arrest. So the arrest for unlawful entry was improper in the view of the district court because there was no evidence of a criminal intent the statute required. The United States Supreme Court lays out the legal standard for probable cause. To determine whether an officer had probable cause for an arrest, we examine the events leading up to the arrest and then decide whether these historical facts, viewed from the standpoint of an objectively reasonable police officer, amount to probable cause. Because probable cause deals with probabilities and depends on totality of the circumstances It is a fluid concept that is not readily, or even usefully, reduced to a neat set of legal rules. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of activity. Probable cause is not a high bar. The Supreme Court notes here the partygoers contend the officers lacked probable cause to arrest because officers had no reason to believe that they knew or should have known their entry was unwarranted. The Supreme Court disagrees. Going back to the legal standard they just announced, considering the totality of the circumstances, the officers made an entirely reasonable inference that the partygoers were knowingly taking advantage of a vacant house as a venue for the party. The Supreme Court states that, taking all the evidence of the party as it was described in the factual background, taking all those elements together, the condition of the house and the conduct of the partygoers allowed officers to make several common sense conclusions about human behavior. Most homeowners do not live in a near barren house, and most homeowners do not invite people over to their living room as a strip club, to have sex in their bedroom, to smoke marijuana inside, and leave their floors filthy. The officers thus could infer the partygoers knew that their party was not authorized. The partygoers' reaction to the officers gave them further reason to believe the partygoers knew they lacked permission, and many of them scattering themselves upon sight. Unprovoked flight upon noticing the police, the court says, is certainly suggestive of wrongdoing and can be treated as suspicious behavior that factors into the totality of the circumstances. The Supreme Court also faulted the lower courts for factoring out any circumstances that could be viewed as innocent explanation in isolation. Referring to the lower court of appeals, the Supreme Court said that the panel majority improperly brushed aside the drinking and lap dances as consistent with the explanation that they were having a bachelor party, and similarly dismissed the condition of the house as consistent with being a new tenant. But the Supreme Court says probable cause does not require officers to rule out innocent explanations for suspicious facts. As we have explained, the relevant inquiry is not whether a particular conduct is innocent or guilty, but the degree of suspicion that attacks to particular types of non-criminal acts. Thus, the panel majority should have asked whether a reasonable officer could conclude, considering all the circumstances, including the plausibility of the explanation, whether there was a substantial chance of criminal activity. So the Supreme Court said that the lower court erred by looking at the factors in isolation rather than in their totality, and factoring out so-called innocent explanations when they were viewed in a more proper light as part of an overall pattern of conduct. Well, that is the story of District of Columbia versus Wesby. As it happened, none of the 21 people who were arrested were ultimately prosecuted for their crimes. Perhaps the police felt there was not enough evidence to go to trial, so none of them were convicted or sent to jail. Unfortunately, none of them can recover for false arrest because the United States Supreme Court ruled the arrest was not false. Arrest only requires probable cause. Probable cause is a fairly low standard. It's based on the total set of circumstances and based on how a reasonable observer would view the situation. Based on all the factors that were in play, a reasonable officer could conclude there was sufficient evidence to effectuate the arrest, even if ultimately there was not enough facts to prosecute, because that's not the right standard for the arrest. So that is the story of the epic house party in District of Columbia. Theodore Wesby may not get any money from the police, but at least he has one heck of a story for the rest of his life. A party so epic, the United States Supreme Court themselves got involved. Until later, my friends, I'm out. Cheers. Bye.